seen it, you've all enjoyed it. But to many of us who have attended or currently attend the University of Michigan, its status is truly something approaching hallowed ground. Heisman Trophy winner and World War II fighter pilot Tom Harmon, President Gerald Ford, and legend Tom Brady, just to name a few, all competed on the field below you. But, as you may have heard, we also know that Michigan Stadium can be intimidating to some people. I want you to think back briefly to November 30th, 2019. November 30th, 2019, a whopping 1,925 days ago. A lot has changed since then. We had a pandemic. We had an entire presidential administration. We have the old guy who's now back as president. A lot has happened in 1,925 days. But November 30th, 2019 was the last time Michigan lost a football game to Ohio State, and incidentally, also the last time large swaths of the state of Ohio felt genuine joy. And if you have any doubts about how deep the Michigan-Ohio State rivalry runs, you shouldn't at this point. As you've heard, despite its geographic proximity, none of them have shown up this evening. We wanted to acknowledge the proud law schools from the state of Ohio that are here this evening, which include Akron. Akron, let's hear it for Akron. You brought a big group. Case Western. Case Western, let's get a hand for Case Western. Cincinnati. Where's Cincinnati's in the house? Yeah, there we go. Cleveland State. Cleveland State's in the house. And last but certainly not least, Capital University Law School, which is actually located in Columbus, Ohio, funny enough. So if anyone wants to do a wellness check on our Ohio State friends when you head back down, I think that'd be great. We are genuinely worried for them. Actually, where's Judge Radler at? Judge Radler, you'd be perfect for this. I think if you want to organize a group and go over there and check on them, that would be great. So please reassure them it's really not so scary here when their train wreck of a football team is absent from the field. Anyway. Thank you. So now that I got that out of my system, we're going to get back to our actual program. I would like to, it's my proud privilege and pleasure to introduce you Chicago's Rex Dykes, the chair of the Joseph Story Award. Rex is a 3L and a comments editor on the University of Chicago Law Review. He received his bachelor's degree from BYU and lives in Chicago with his wife and 2 kids. I've also been reliably informed that he's a stellar guitar player and does a mean Billy Joel cover, which we unfortunately can't hear tonight. But please join me in welcoming Rex.
Thank you. Good evening. It is an honor to be with all of you tonight, and it is my privilege to present the 2025 Joseph Story Award. The Joseph Story Award is given annually to an up-and-coming academic who has demonstrated excellence in legal scholarship, a commitment to teaching, a concern for students, and who has made a significant public impact in a manner that advances the rule of law in a free society. Its namesake, Justice Story, was a prolific scholar, jurist, and public servant whose sharp legal mind and keen wit helped guide our nation through her early years. Few scholars today embody Justice Story's extraordinary career more fully than this year's Story Award recipient, Professor Judd Campbell. Professor Campbell is a professor of law and the Helen L. Crocker Faculty Scholar at Stanford Law School. Before joining the faculty at Stanford, Professor Campbell served as a professor of law at the University of Richmond School of Law and as a visiting professor at Harvard Law School and the University of Chicago Law School. His impressive scholarly works have appeared in the Yale Law Journal, Stanford Law Review, and Harvard Law Review, among various other journals. Professor Campbell is best known for his scholarship on the First Amendment and the history of the Constitution. One of his most thought-provoking articles, Natural Rights and the First Amendment, challenges our contemporary understandings of free expression freedoms by representing a compelling account of how the understandings of free expression, of how the founders viewed these freedoms, not as the legal trumps as we often view them as today, but as natural rights that, while expansive in scope, allowed for restrictions of expression to promote the public good. In just a few short years, Professor Campbell's work has had a profound impact on legal scholarship and the law, reshaping contemporary understandings of constitutional history and free speech doctrine. Professor Campbell's work is not only academically outstanding, but also a powerful unifying force for the public good. At a time when legal discourse is often deeply polarized, his scholarship brings together diverse perspectives, fostering a more constructive and inclusive intellectual conversation about the law. His commitment to engaging with scholars across a wide spectrum of methodologies and viewpoints demonstrates his belief in the value of open dialogue. The fact that both staunch defenders and thoughtful critics of originalism recognize the significance of his contributions is a testament to his role in bridging divides and promoting a more cohesive understanding of the law's most pressing issues. Finally, Professor Campbell is a dedicated teacher and mentor to his students. In his short time at Stanford, Professor Campbell has built strong connections with students both in and out of the classroom, advocated for them in their pursuit of clerkships, and actively engaged them in his research. Professor Campbell's unwavering dedication to his students serves as a commendable example for all of us to follow. I'm now honored to present the 2025 Joseph Story Award to Professor Judd Campbell.
Thank you so much, Rex. I'm humbled to join so many wonderful past recipients of the Story Award. And I'm especially glad that somebody out there is still paying attention to those of us who aren't on social media. I write as a historian, and one of my favorite parts of the job is trying to learn about how differently the founders thought about the Constitution. I want to frame my remarks around two of those differences. One relating to their idea of constitutionalism, and the other relating to the common good. So let's start with the idea of constitutionalism. We're used to thinking about the Constitution as a legal document, something that it's principally up to judges to enforce and interpret. And so we treat politics and constitutional law as separate domains. The founders had a different view. It's true that by the late 1780s, many of them were open to the judicial enforcement of certain well-settled rules, but judicial review was just one piece of the puzzle. Just consider Madison's Federalist 51, which was all about constitutional enforcement, but didn't even mention judicial review. Instead, Madison was focused on institutional design, on things that shape political relationships and foster certain ways of thinking, certain norms. And his core insight is one that other founders shared. That insight is that fidelity to the Constitution depends far more on constitutional culture, both within government and in the public at large, and less on judicial enforcement. It requires that all citizens and all politicians, not just judges and lawyers, know and care about the Constitution and its underlying principles. This is why the founders are so obsessed with education and with other ways of developing civic virtue, including religion. Promoting constitutional culture is also the primary reason why Madison offered the Bill of Rights, which he said wouldn't create new rights, it would just, to quote, establish the public opinion in their favor. So my first point is the founders had this much broader sense of what constitutionalism was all about. Judicially enforceable constitutional law was supposed to be only part of a much bigger constitutional picture. And that ties to the other concept I want to mention, the common good. The common good was a central idea in founding era constitutionalism. As the founders saw things, the political society itself was formed to advance the common good. So that concept became the guiding principle for every exercise of public authority, every legislative vote, every executive action. The common good was their constitutional North Star. So what did it entail? Well, it was the good of the political society and its members, the general welfare. Its opposite was corruption and factionalism, the narrow pursuit of private interests, or the interests of only those in power and their supporters. In essence, pursuing the common good required the rejection of tribalism. It required considering everyone's interests equally, and only then discerning the good of the whole. This is what Madison was talking about in Federalist 51 when he famously warned against, quote, the oppressions of factious majorities, violating the rights of the minority. He's not talking about judicially enforceable constitutional rights. Rather, Madison is referring to the majority's disregard for the common good, the willingness of factions to use politics to simply capture wealth and power and to pursue their own interests at the expense of their rivals. Of course, he recognized that men are not angels and that we can sometimes harness self-interest in useful ways. But the key point here is that constitutionalism is about a lot more than just following particular rules. It's about ensuring as best we can that all political power is exercised justly and for the right sorts of reasons, and with equal regard to all of our fellow citizens. So where does that leave us? Well, today we've taken a much narrower view of constitutionalism. Constitutional law only sets the political ground rules, and otherwise politics is just hardball. And hardball is a competition for power. Norms that aren't judicially enforceable are disposable, and the trash bin is rapidly filling up. We can do better. The founders appreciated that politics won't ever be perfect, but more perfect self-government is always achievable and very much worth pursuing. And that responsibility resides with all of us. We can still debate the meaning of commerce and executive power, or what methods of constitutional interpretation to follow. And those debates really do matter. But as constitutional problems go, they pale in comparison to having a political order dominated by tribalism with a lost sense of common purpose. And it's on each of us to do better, to not let ourselves get siloed, to understand and care about each other, especially across difference, and to not lose faith in a better tomorrow. Thank you.
Congratulations, Professor Campbell, and Stanford's very fortunate and blessed to have you. We're going to go ahead and take a 10-minute dessert break. So dessert's going to be coming around, and then we're going to continue with the rest of our program. All right, if you want to sit back down, we're going to go ahead and get started with the main event. Please take your seats. Please quiet down. While you take your seats, I'm going to tell you a little story about the online chatter we heard upon announcing that Mrs. Ho and Judge Ho would be joining us here this evening. So I first have to ask, does anyone know what the Blue Sky app is? Does anyone know this? Boo? Okay, I was not aware what this was prior to a few weeks ago. There's some more connected people in our chapter, but it's basically X for left-wing activists and legal academics, which seems redundant to say, but Professor Walker insists it isn't. But anyway, it is relevant for our purposes here because I've been informed that upon learning we would host this fireside chat at the Big House, a handful of Blue Sky users question in very blunt terms how Mrs. Ho and Judge Ho could possibly draw 110,000 students to come see them speak. 110,000 seats in the Big House, third largest stadium in the world. Well, as it turns out, there are almost exactly 110,000 total law students in the United States. So I think you two should feel flattered that the average Blue Sky user thinks that every single law student in the entire United States would show up to our symposium on account of you being here. Unfortunately, we only have a capacity of 440, so it should make us, the lucky privileged few in the room, appreciate what a treat it is to have you here tonight. So let's give them a round of applause as they make their way to the stage. Judge James C. Ho sits on the U.S. Court of Appeals for the Fifth Circuit. Before taking the bench in 2018, he was a partner and co-chair of the National Appellate and Constitutional Law Practice Group of Gibson, Dunn, and Crutcher. As an appellate litigator for over a decade, including 3 years as the Solicitor General of Texas, Judge Ho presented 50 oral arguments in federal and state courts nationwide. He won numerous appeals, including 3 merits cases at the U.S. Supreme Court. Judge Ho has served in all 3 branches of the federal government. On the Senate Judiciary Committee, he served as chief counsel of the subcommittees on the Constitution and Immigration under Senator John Cornyn. At DOJ, he served as special assistant to the Assistant Attorney General for Civil Rights and an attorney advisor at the Office of Legal Counsel. He clerked for Judge Jerry E. Smith of the U.S. Court of Appeals for the Fifth Circuit and Justice Clarence Thomas of the U.S. Supreme Court. In addition, Judge Ho has served as an adjunct professor of law at the University of Texas School of Law, where he taught seminars on U.S. Supreme Court litigation and religious liberty. He has authored numerous articles in respected law reviews nationwide. Judge Ho graduated from Stanford University with honors and a BA in public policy, and the University of Chicago Law School with high honors in 1999. Impressive record, yet a prominent U.S. senator from Texas has apparently claimed that Judge Ho is only the second best lawyer in his household. And after hearing his wife's bio, you will perhaps see why. Mrs. Allyson N. Ho is a partner in the Dallas office of Gibson, Dunn, and Crutcher, and co-chair of the firm's nationwide appellate and constitutional law practice group. Mrs. Ho is one of the premier appellate lawyers in the United States. She has presented over 100 oral arguments in federal and state courts nationwide, including multiple high-stakes cases before the U.S. Supreme Court. She has appeared before every federal court of appeals in the country, including en banc arguments before the Fourth and Sixth Circuits. Mrs. Ho also regularly appears in state appellate courts across the country, including here in Michigan. She has argued numerous cases in the Texas Supreme Court, Texas appellate courts, and 6 other state appellate courts. Mrs. Ho also served as special assistant to President George W. Bush, counselor to Attorney General John Ashcroft, and law clerk to Judge Jacques L. Wiener, Jr. of the U.S. Court of Appeals for the Fifth Circuit, and Justice Sandra Day O'Connor of the U.S. Supreme Court. She has also been elected as a member of the Administrative Conference of the United States, a trustee of the Historical Societies of the United States Supreme Court and the Texas Supreme Court. Mrs. Ho graduated from Duke University magna cum laude with a BA in English, Rice University with an MA and PhD in English literature, and the University of Chicago Law School with high honors. She was a member of the Law Review and Order of the Coif. Mrs. Ho and Judge Ho live in Dallas, Texas with their twin daughter and son. And to moderate tonight's discussion, we have my fellow 3Ls, JJ Marshall and Katherine Slivensky. Katherine is our chapter president, and JJ has been in the trenches all year preparing for tonight as our symposium logistics director. I know how much they are looking forward to this opportunity to interview you both. especially since JJ is a proud Texan who may or may not have a tattoo of the state of Texas somewhere on him. And Katherine aspires to balance a successful big law career with family life in the future. So JJ, Katherine, Mrs. Ho, Judge Ho, over to you.
It's on my arm.
Nobody was asking.
My wife wanted me to make that clear.
Well, thank you guys so much for being here tonight. We have a lot to ask you and to talk about. So an overview of what we're trying to cover in 35 minutes. We want to talk a little bit about your family life and how you managed to be such a prominent couple in this legal industry. A little bit of substantive law, First Amendment, administrative law, judicial independence, just light things. And then a little bit of parting advice for the members here tonight.
But first, I do want to take this opportunity. We've heard a lot of Michigan pride here tonight. As a fellow Texan, people who live in Texas, sit in Texas, work in Texas, I just want to ask you guys, what's the second best state in the union?
Oh boy, that went in a different direction than I expected. Well, look, this seems like a great, fun, rowdy crowd. I could try to test how rowdy it is by saying the second best state in the union is clearly Ohio.
That backfired.
All right. I was just testing the crowd. I don't know. That's hard. I guess I'll answer as a parent and say that we have had some of our best family vacations in the states of Florida and Utah.
Fantastic answer.
Great. So we did reach out to a couple of your former clerks and colleagues to do some of research
Why
of
would
our
you do
own and ask them to describe both of you in 3 words. And majority of the words that we collected were principled, fearless, and loyal. And you attended the symposium both as students, which the symposium, I believe, was organized under the fierce administration of the chapter president, Rao. So can you tell us a little bit more about how both of you met and what your experience in law school was like?
Sure. I guess if I can begin this way with the blue sky stuff, which I confess I'd never heard of. I hope there's like worse stuff about us that you didn't say, because I'd feel like I'm not like doing what I should be doing. If that's like, right? If that's the worst that's out there. So I just had to put that out there. So we actually have divergent views on when and how we met. But I'll tell the official Jim Ho version of how we met tonight. So I was a 1L and was walking into a Federalist Society meeting. And I walk in with a friend of mine, and right before the meeting, she had shared with me that she'd figured out law school just wasn't for her, and she was going to finish out the quarter and then go on and do something else. So the two of us walk in together, and the president at the time, Michelle Boardman, comes up to us and says, well, look, we're having our election for 1L representative today. And right now there's only one person running, and we kind of like to have we'd like to have a real election. Would you guys, agree to run? And so she's like, well, you do it, because she knew she wasn't going to be sticking around. And I thought, well, how hard can this be? Like, put my name on a ballot, right? Sure, I'll do it. Well, then I learned that the University of Chicago way of electing a 1L representative is the candidates, Lee's laughing, the candidates stand in the well of the classroom and field questions from the audience. So it's quite the Chicago experience, right? And one of the questions was, how many current FedSoc officers can you name? And so I knew Michelle Boardman was the president. I think you were vice president of speakers at the time, Judge Rao. And Jim was the treasurer. And I remember you came up to me afterwards and said, well, nobody ever knows who the treasurer is, and that he appreciated that. So that is the.
That's a great opening line, right?
Yeah.
Yeah, Zach, how do you feel about that?
I got moves.
It worked.
Sounds like Zach should be telling folks that he is the treasurer of our chapter more often. That is a great story. So just to segue from that, how do you manage to have such a prominent career and family life, and such a great marriage? Can you share a little bit of tips for both of us who are married, but a lot of folks in the room who also wish to be, both working and having a kind of a stable, successful family life?
Well, I'm going to invoke Justice Thomas here, because in addition to all the various ways in which he's been a source of wisdom to me and so many others, he's actually been a source of great marital wisdom. One of the things he told us as clerks was every morning he wakes up, he turns to Ginny, and he says, "I'm sorry." And his theory is just might as well get ahead of the day. And we have, I've adopted that tradition as well.
I did see JJ's wife clapping for that. Just keep that in mind.
So I guess what I would add to that is, as a Christian, I live under the rule of do everything as unto the Lord. So whether I'm working or mothering or wifing or daughtering, everything is touched with that sense of what gives it worth and meaning is who it's done for, and doing that unto the Lord. And I think that, you hear a lot about work-life balance. I think that's just really hard, and I'm not sure that's the right way to think about it.
That's good. My wife has no interest in working, so we're going to try to strike that balance a slightly different way. But that's great advice for all those power couples out there. Speaking of law schools and when you guys attended, things are a little different now, back from when you guys attended law school. And Judge, you've initiated your own sort of federal hiring freeze on a few institutions, one could say. How do you feel that's going? How do you feel, what is the current state of law school institutions specifically, but higher education in general, as far as free speech and freedom of thought go?
Well, let me try to answer this in a positive way, because you asked, I think, what was it like for us as students? I have to say, I had a great time at the University of Chicago Law School. And it's not because everybody agreed, and it's not because it was easy. It was actually, I remember being very stressed out at various times in law school. But I was constantly learning. I was constantly interacting. I got to be engaging with people all across the spectrum of views on every possible issue. We had faculty across the spectrum. The way I thought of Chicago was, there wasn't really any sort of dominant viewpoint. The one thing you could be assured of was that no matter what view you held, no matter what position you expressed, you could count on being attacked, but in a good way, right? Iron sharpening iron. You're actually learning. I don't understand the dynamic today where if somebody disagrees with you, then people decide you want to target them. Least of all in law schools. I mean, I'm of the view, you mentioned we're both appellate litigators. As appellate litigators, one of the most important things you do is to moot a case. What do you do with a moot? You get members of your moot who not only know nothing about your case, but they're going to attack you. That's the whole point, right? You want to get ready for all the toughest questions. Well, there's no better way to get ready for that experience, whether you're an appellate litigator or any kind of litigator, than to be constantly challenged in the classroom, on campus, in the law school lounge. I learn nothing from talking to people who agree with me. The good news is, you're never going to find anybody who agrees with you on everything. But that's where you learn, is when you talk to somebody who has a totally different viewpoint and yet is a good person, yet seems to have good values, but has come to a different conclusion for whatever reason. That's how you learn. You might find that you're wrong. You might find that they're wrong, but you have a new way of understanding or a better way of arguing. But either way, you have a good chance of coming out of that a better person. So I just fundamentally do not understand the culture on campuses today at all. It's completely alien to me.
So I'm coming up on my 25th year since I graduated. And I just think it's really important for those of us who came before to acknowledge how hard and how bad it is out there on campuses for you all today. 25 years ago, was I still asked as president of the Chicago chapter, there were still discussions around, well, should I put FedSoc on my resume when I send it around? My answer today is still the same, yes, but I realize that the consequences of doing that are much more severe and potentially serious than they were back when I was in law school. And I'm like, Jim, I want to think about a positive way to talk about it. And so when I think of all of you in the room and back on your campuses and at the very beginning of your legal career, standing up and being courageous, the least that those of us can do who have decades on you in the profession is to stand up and be courageous ourselves. We can't ask you guys to do that. It's not fair. At the very beginning of your career, if we're not willing to stand up and be courageous ourselves, and all of you are an incredible inspiration to us, and you're a big part of what gives us the courage in big ways and small to stand. So thank you for that.
Thank you guys for standing up for us.
So turning to some substantive discussions. Recently, the ABA and the Federal Judges Association has spoken out against attacks on judicial independence. This is for Judge Ho primarily. What is your reaction to those manifestations? Do they represent a unified concern for the judiciary, or are they a product of some sort of selective outrage, something in between? What do you say, Judge Ho?
Yeah, so for those of you who don't know, the Federal Judges Association came out with a statement, I guess I want to say Tuesday night of this week. This is an association that really is just, it's normally doesn't do anything like that at all. It sends us newsletters about, judicial education and those sorts of things. So I'll put it this way. I was very surprised by that statement. And the next morning I sent an email to the organization saying that I wanted to resign. And let me explain why. I researched for myself, and I also asked the association if they ever issued any such statements when Justice Thomas received attacks, or Justice Alito. Justice Kavanaugh dealt with an assassination attempt. We've had federal district judges in Texas and Florida, as well as I'm sure other states, but those are the ones that come to mind immediately, all faced the kinds of things that that statement was complaining about and more. Did we see these statements in 2024 or 2023 or 2022? From what I can tell, no. I researched my archives and found no such statements. And when I asked, no such statements were provided to me. You can't say that you're in favor of judicial independence only when it comes to decisions that you like. That's not protecting the judiciary, that's politicizing the judiciary. And I actually think that statements like this, whether intended or not, I actually think harm the very cause that they're trying to further. Because one of two things turns out to be true when you're selective in this way. And either of these options, I think, is a bad thing. Option number one is that you're basically lying, that you actually don't care about this principle because you didn't stand up for it when the shoe was on the other foot. And so you're essentially telling the world we're not actually seriously committed to judicial independence. The alternative is perhaps even worse, which is that you are telling the truth, you do care about this, this principle, whether it's judicial independence or free speech. I think this concept applies to a lot of things. If you're telling the truth, you really care about this principle, but there are just some people who have views that are so anathema to you that you don't think they are worthy of this principle that you expound on. And so what you may think is a statement born of righteousness, I think is perceived by a lot of people as merely sanctimonious. And so if you're not willing to stand up when that principle is at stake, in a way that costs you, then it's not really a principle at all. I'm reminded of, I think it's the Book of Psalms, there's a quote about, an oath really only means something if it costs you.
Well, and to pile on a little bit, we're hearing a lot of voices about threat to rule of law and criticizing lawyers, right? Based on the clients that they represent. I don't remember hearing these voices speaking out when lawyers were criticized for representing President Trump. I don't remember these voices speaking out when lawyers came out of the first Trump administration and they were not hired, including firms that they had been at and been partners at before going and serving their country in the administration. So I strongly agree with what Jim said. When you're not being consistent about it, then it can only be about whose ox is being gored, and the sense that in a way only underscoring that the rule of law means one thing if you agree with me, and another thing if you don't.
So I want to turn us to another one of y'all's interests, free exercise. We both took First Amendment last semester together. Shout out to everyone who's in Dunn Herzog's First Amendment class. It's a fantastic class. But when we got to the end of the course, we had done a lot on free exercise and establishment clause, read a lot of O'Connor's opinions. But when we got to the end of the course, we read Carson and Kennedy. And I wanted to know, the court seems to be becoming more amenable towards free exercise claims. Can we maybe give some hope to the room for those of us who are religious and see, where do you think the court is going to go as far as, what do you see on the horizon for free exercise and maybe possibly more establishment clause claims in the future?
Sure, so I'll take that. And I think you're right. We've really been playing defense for a long time, primarily on the establishment clause side. Like when I think about cases like the Blanesboro Cross case, right, where it was a veterans memorial in the shape of a cross. And on one hand, how devastating it would have been if the Fourth Circuit decision that memorial violated the Establishment Clause, what a disaster it would have been if that had stayed the same and had remained the law, and the monument would have had to been taken down. Or, as one of the judges on the Fourth Circuit panel asked during oral argument in the case, well, why don't you just cut the arms off the memorial, and then it won't look like a cross anymore? It wasn't a joke. I mean, this was asked in real seriousness. So it would have been devastating had we not won. But you sort of think okay, well, we don't really move the ball forward, right? We just get to keep what we have. And there's a lot of bad precedent. There's just a lot of bad case law on this. And so I'm really excited and encouraged about where we're going, particularly to the extent that free exercise means certainly, but doesn't just mean you have the freedom to pick the church or the synagogue or the place where you want to worship, but that you are free to exercise your faith in all aspects of your life. And we'll be filing a petition this week in a case that raises what I think is a really important issue on free exercise that actually will benefit all sorts of rights holders in making it easier for people who want to challenge unconstitutional laws that restrict the exercise of their religion. Will open avenues for those people to be able to do that. So I am this is one area where I'm very positive. Look, it's not going as fast as I would like it, but definitely moving in the right direction in an encouraging way.
Just a follow-up for that, Allyson, what are some of the big questions that the court now has to answer? What are some of the remaining things that need to be either doctrinally cleared out that you would, foresee as a priority?
So, from my perspective, I'm firmly in the overrule employment division versus Smith camp. I think it's time to do that. And to me, that's sort of like clearing away what's sort of impeding. I kind of see that as kind of the next big frontier on that score.
Our next question is about administrative law. We're wondering the conservative and libertarian movement expended a lot of effort in overturning Chevron, and in this post-Loper Bright world of administrative law, how are appellate litigators such as yourself approaching challenges to agency actions differently, if at all? And what is the role, if any, again, of the emergency docket in some of these strategic considerations?
So I first want to put in a plug for, Loper Bright was one case, but the companion case was called Relentless. So I'm kind of on a campaign
To rename it.
like when we talk about the case that overruled Chevron, relentless.
Sort of like Loving versus Virginia, right?
Yes.
That's a cool name.
Yes, exactly. Well, where to start on this score? I guess maybe I'll mention something that may not be top of mind. I know y'all have had some fantastic panels today on these topics. Chevron is really about saying, interpreting statutes and laws, and I think, it's great and very important to have that settled. But when you think about it, the whole foundation of the administrative state is the idea of expertise and agency expertise. And to me, that's the next big frontier in administrative law. There's a doctrine, and the word actually used is super deference. Courts should pay super deference to agency findings that are in the wheelhouse of that agency expertise. Well, you can just hear me talk about that and recognize the opportunities for mischief in a doctrine like that. So that's where I see kind of the next frontier. If your project is, as mine is and has long been, dismantling the administrative state, I think kind of challenging this notion of really kicking the tires on expertise and that as a basis for deferring to agencies is probably, won't be anytime soon, but I think that's likely to be the next frontier.
This is for Judge Ho. You're a naturalized citizen. And in your article, Fair Weather Originalism, you quoted President Reagan saying that, quote, "Every once in a while, all of us native-born Americans should make it a point to have a conversation with one who is an American by choice. As a soon-to-be naturalized person myself, I am wondering, why should people in the room talk to me?"
What a wonderful question.
I need one good reason, please.
I think, look, I think there's something about the sort of the unique passion of the converted, if you will. I think what President Reagan was getting at is that you may have a special appreciation, having not been an American from birth, as I was not, what it means to now be an American. The way I think of it is, I wasn't born an American, but I get to thank God every day that I will die an American. Honestly, the best thing about my job is the fact that once a year I preside over a naturalization ceremony. It's actually not something that circuit courts are allowed to do inherently. I have to get a permission from a district court to do it, and I do it every May as sort of a kind of a personal anniversary for my own naturalization back in May 1982. It's an amazing, for those, if you've never been to one, you really should try to go to one. Imagine a room full of people from literally all over the world, different backgrounds, different religions, different viewpoints, different experiences, all coming together in one room for one purpose, to become Americans. It is, I just always come out of that inspired about, for whatever issues that continue to divide us as a country, we remain the single country that more people around the world would do anything to come to. People come, and people come to this nation in droves, not because we're a failed nation. They come to our country because this is the greatest country in the history of mankind. And I'm so thankful that I get the opportunity to preside over those ceremonies.
It's beautiful. Ginger.
Okay, so we have, I think the number was 440 young budding lawyers in here, some a little younger than myself, but give us some parting advice. You talked about, things that standing up and how you guys have been standing up for this movement and, standing up for what you believe in. What can we do as chapters and as individuals, while we're in law school and also when we get out into the field and start practicing, that can help, be more like you guys and, make a difference?
Well, let me follow up on some of the things that Allyson said earlier. We could say, to students, just be brave. Just say what you believe. I think that risks coming off as very smug. I'm a life tenured federal judge, right? Allyson and I have an amazing, she has an extraordinary career at her firm. Y'all are just starting out. I mean, you guys, your job is to work hard, get good grades, and get a job, right? I mean, no, seriously, it is not for you guys to be fighting these fights. It's why I wanted to follow up on what Allyson said in terms of, this is really on the grown-ups to be, running schools the correct way, to be enforcing the rules consistently, et cetera, et cetera. So look, I mean, having said that, yes, I mean, if you have a viewpoint and you are comfortable standing up for it, no matter how unpopular, good for you. I mean, I'm certainly not trying to say otherwise. I just think it could be smug saying, just be brave. Having said that, I will say this: if you can't be that first person, I mean, if you can, that's great. But if you can't be the first person to speak up in a classroom, on campus, in the student lounge, at least try to be the second. If somebody else sort of sticks their neck out and says something that, cause a bit of a stir in the room, try to stand up for that person. You don't even necessarily have to agree with them. I mean, one way to do it is say, look, I'm still thinking about what you said. I'm not sure I agree with it, but I'm kind of curious what the counter arguments are. Something, and obviously if you do agree with them, then great. I don't know how many meetings I've been at, as a litigator in government service where, there's sort of an argument on the table, and I have this vision in my mind of, I think that's totally wrong. I'm debating whether to say something. There have been times when I almost said it and instead somebody else said it, and it turns out everybody in the room actually agreed with it, and I'm sort of kicking myself, right? This was when I was younger. I've just determined, just say it. So in terms of the advice, what I would say is don't be afraid to be wrong. You can always admit that you're wrong. I do it all the time. And also don't be afraid to be right. I mean, you may very well have the majority of the room behind you. It's just that nobody else is willing to stick their necks out.
Allyson, for those of us who aren't as fortunate to, go work at Gibson and Dunn or Jones Day, but want to be associates and, spark a movement, what can we do as conservatives and sometimes hostile or, unfavored to conservative views in these law firms?
Sure. So I just want to echo something Jim said, which is I don't want to be smug, like, oh, well, here's what you should do, right? Or give advice. Maybe the best way for me to answer is just to tell a place where I have recently changed my view or my approach to something. My view used to be in the pro bono sphere. You know, if an associate came to me and said, hey, this is probably going to get approved, and I'd say, yeah, you're right, it's not. So let's quote unquote conserve our capital, right? Let's really go for things that we believe, like, we've got a real shot at. And I've changed my view on that for a couple of reasons. Number one, I think it's important for associates to know that there are people in the firm who are farther along than they were, to kind of pick up on what Jim said, right? Who are partners and practice group leaders, who are willing to put something forward like that. I also think there's value in being told no, because no one can ever say, oh, we didn't know you wanted to do that kind of work, right? Nobody asked us. And so that's just an area where in my own life and my own work, I've just sort of changed and thought, you know, I don't have to be a flamethrower every day, but I can, you know, this I can do, right? When someone comes to me, or if someone comes to me from outside the firm with an opportunity, I'm much more comfortable with being told no. If that's the worst thing that anybody can say to me, then I live a really privileged, comfortable life.
That's beautiful. Allyson and Judge Ho, we have a surprise little for you, and we'd like to ask, what did that moment feel? So this is right after. This is right after your first Supreme Court argument, to have your kids just run up to you into your arms. What did that moment feel like? As someone who very much looks forward to one day being a mother, I'd like to know, get a glimpse of that moment.
So it was such a precious moment. And what really made it precious was Jim had pulled it off. It was a surprise that what I thought was going to happen was that after the argument, I would go back to the hotel, and later that day, Jim and the kiddos were flying in, because I actually had another argument 21 days after my first one. So I was unfortunately going to have to stay in DC and prepare for that. So Jim was going to bring the kiddos up. So I was expecting to see them, but I was not expecting to see them on the steps. So I'll let Jim fill in the backstory of how that came to be.
So, believe it or not, this actually took some effort. First of all,
We believe it.
First of all, that was actually like a really high quality photo. I got the, I don't know if it still exists, the Legal Times, their official photographer took those pictures. So, you know, as you can imagine, the kids were tiny back then. And Allyson had to be away from home for a long time. And so I decided, you know what, rather than showing up the next day, I think was the original plan, we flew them in the night before. So that we could have this sort of courthouse moment. But it was essentially a conspiracy, right? First of all, as some of you know, if you've been in the Supreme Court, that's not the only way to get out of the building. It's not even necessarily the easiest way. You know, the coming down the steps is sort of a dramatic, you know, great photo op, but there are other easier ways to get out. I had to make sure that she was going to go that way. So I needed to coordinate with her second chair to make sure she walks down this way so she sees us. We definitely did not stay in a DC hotel. I just sort of had this image of, you know, bumping into her at dinner or something and completely ruining the surprise. So we stayed out in Virginia. Anyway, I carefully planned this. We get off the plane, me and the kids, and we're walking, and we bump into Ken Starr, who, you know, as some of you may, if you had the pleasure of knowing him, just one of the friendliest people. And he comes up and, oh, you know, it's great to see you. What are you doing here? And then we just had a very nice moment. And he was president of Baylor at the time. So he was not a DC person back then, at that time. And so, you know, I walk away and I realize, I stop for a moment and think, well, wait a minute, what is he doing here? is it possible he's going to be at the Supreme Court the next day? Is he going to see Allyson, at the council table, and is he going to tell her? But I decided, you know what, I'll just let fate decide. As it turns out, he was there to swear in Baylor alums, I guess, to the Supreme Court bar, and he actually did mention this to Allyson. But I decided, you know what, this is great. I now have something in common with Bill Clinton. Right. I was trying to hide something from my wife, and Ken Starr exposed us.
On that note, I think we'll wrap up for the evening, JJ.
Yeah, guys, can we give a hand for Allyson and Judge Ho?
This is great.
Thank you guys so much for being here, and thank y'all for standing up for all of us in this room today. Thank you guys so much.